Welcome everyone to our first webinar of 2025, our legal landscape. This is always one of my favorite ones to kick off the year. I hope you all weren't waiting long for this one. So thank you everyone for joining. We're going to get into a little bit of housekeeping and then I'll let our panelists introduce themselves. So just a couple of things. You will receive the recording and slides after this webinar, generally within about 24 to 48 hours. And we also do have a Q&A box, so please feel free to use that. If we don't get to your question during the session, we will follow up with you after. So we'll get to all the questions. With that, I will have Jonathan introduce himself.
Hey, Mary, thanks for having me. My name is Jonathan Greenblatt. I'm the Vice President of Legal here at LinkSquares and happy to talk about all these topics. I feel like this is now an ever-changing landscape by the not only day, but by the hour these days. So this will be a fun conversation.
Absolutely. Just got to keep your notifications on just in case something changes during the webinar.
Breaking news.
Yeah. Andy, what about you?
Yeah, great to be here. Thanks for having me, Mary. Andy Lunsford, co-founder and CEO of BreachRx. I come from the data breach litigation world, spent 20 years data breach litigation, privacy law, cybersecurity law, which is an area that always changes every year, and it seems to not be slowing down at all, as we'll talk about here in a bit.
And I'm Mary. I'm on the brand and comms team here at LinkSquares and run these webinars from time to time. So thank you for joining us. All right, moving into a few noteworthy items from 2024. As we all know, AI became widely used across the board. Marketing teams use AI, legal teams use AI. Everyone is figuring out a way to incorporate it into their day-to-day. And with that, cybersecurity policies have changed throughout 2024. And something that we also talk about from our side of things is reporting on verifiable metrics, the ROI of what you're doing as a legal team, and then everyone's favorite phrase, doing more with less, and really figuring out the most efficient way to operationalize what you're doing. But something really noteworthy from 2024 that I'll have Andy touch upon is NIS2. Andy, do you want to talk about what went into effect in October 2024?
Yeah, NIS2 didn't really get as much publicity, I think, in the US because it's an EU regulation, but we look at all the global 200 plus regs in this space, and it is by far the most prescriptive data breach, privacy incident, cybersecurity incident oriented regulation we've seen to date. A very, very wide variety of incidents are covered. Doesn't require that you have personal information involved, which has often been a trigger for a lot of US oriented regs. And GDPR that people know a lot about, but very robust reporting requirements, very fast reporting requirements, not only just like a 24-hour clock, but also updates throughout and a final report at the end. And I think what also is interesting is kind of in the same way in the US where we had an initial proposed language that a lot of states started with, and then they each kind of modified to their own liking, and then we ended up with 50 different laws that apply different ways. The same type of adoption is happening with NIS2. All the member states of the EU were supposed to adopt it by October 2024. We've only gotten 6 so far that have come through, but even amongst those 6, you're already seeing pretty significant differences in the way that they've adopted those laws. They're all prescriptive and have some commonalities, but they also have their own nuances. So something that we'll be watching closely as each country adds theirs this year, I would expect. But yeah, very, very big change and kind of really a continuation. If you look at what the US did with the SEC reporting, it's a lot of those similar themes. Also, if you look back at CERCIA, I know we've talked about on previous webinars, the critical infrastructure law in the US, a lot of similar pieces there too. So I would just continue to look for, it's going to be more and more robust, more and more documentation, more and more transparency about how you run your cybersecurity program. That's really what NIS2 is getting into.
Thank you for that update. One more noteworthy thing from 2024 that Jonathan's actually going to dive into was one kind of crazy case, outside the box case. So Jonathan, do you want to give us a few more details on this case and really what the implications were with it?
Yeah, so I always love a case that shows the value of what legal departments do and offer their clients, particularly in-house legal departments. And one of the areas where I've done a lot of work historically in my career is reviewing marketing collateral. And so I feel like this is a great case that exemplifies the dangers of not thoroughly reviewing your marketing collateral and errors that I've actually found in doing my own reviews and internally at other companies, and even at LinkSquares, where we're reviewing marketing collateral and we do a little bit of QA that actually ends up providing a lot of value. So in this case, and some of you folks may have heard about this, but there was a toy maker who was licensing the movie Wicked's line of dolls, and they were manufacturing and selling these dolls. And on the back of the box, they printed a website you could go to for more information, www.wicked.com. Well, seems like somebody probably should have proofread that a little bit better. And in a best case scenario, it's not the website for the movie or the doll, and it would be about a Boston sports team or a blog about Boston sports, or maybe some recipes that you can make for wicked boil and trouble. But no, this one actually led visitors to a hardcore porn website, and obviously a doll marketed to children. Some of the children went on the link and discovered this. So there was actually a lawsuit late in 2024 on a class action basis alleging negligence and a host of other causes of action resulting from this packaging. Again, I do love a good case that does exemplify the value of what many of our in-house legal teams do.
Thank you, Jonathan. Yeah, I think that's like such a great point of why partnerships are so important between different teams. Legal having partnerships with marketing, always important to run things by your legal team. And with that, we can actually talk a little bit about a survey that we did about key trends for legal teams in 2025. LinkSquares conducted a survey of over 150 legal professionals just to find out what people were really looking to do for the new year, things that they cared about. And one of the things that came up most often was really partnering and aligning with other teams in the organization. So legal aligning with the executive team and the leadership team, aligning with sales and speeding up that contract management review. And then also just ensuring that everybody's on the same page is like really one of the biggest things. And I think that this case kind of exemplifies why that's so important. So we actually will send out this survey, an entire ebook that really outlines all of the important trends and priorities heading into 2025. So just want to get into that a little bit before we really talk about the new laws that are coming into effect and some that have already gone into effect. We are now over 3 weeks into Q1, into the new year. So a lot has happened already. So Andy, I'm going to pass it off to you to walk everyone through what they should expect this year and to chat through some of the things that have already gone into effect over the past 3 weeks.
Yeah, as is always the case in the privacy and cybersecurity world, we've got a whole new slew of regulations that are coming into effect this year, more coming into effect next year. As you can see, I won't read through each one of these on the slide, but we've got 8 new data breach laws in the United States, or privacy laws in the United States that are going into effect. A lot of these follow, I would say, broadly speaking, they all have their own nuances, but a lot more of the methodology of CCPA, CPRA, some of the newer laws that are a little more GDPR-like, where you're really looking at consent issues, your ability to ask for information to be deleted, the push to have your company regularly doing privacy assessments on different types of data processing activities that you may want to do. So just more of the same in that way, and that we're continuing to see that become more and more the standard across every state, and we'll see more come into effect in 2026. One I will note down here at the bottom, kind of related again to, I talked about NIS2 earlier, but another financial services oriented law that's a pretty big deal is DORA coming out of the EU. Again, it's taking, I would say, the reportability, the transparency that is expected from your cybersecurity program to the next level. It was already the case that we were seeing people feel like, hey, security incidents in our program need to be audited like financial statements and financial records. I'd say DORA and NIS2, similar to the SEC laws and New York DFS, United States, are doing that again and just taking it up another notch. So I would just expect to see more of that happen this year. And we'll talk about the administration, and I think a little bit later as well. But I think there's also a feeling in the privacy and cybersecurity world, although we may see changes in regulations in other ways, this is an area that's a little more bipartisan. You see both Republican administrations and Democrats pushing for different types of regulations and different types of actions against companies in this space. So it's not necessarily a place that I would say is going to be less regulation going forward.
Andy, I feel like we talk about this on every webinar. Do you think now's the time for federal legislation? I think everybody's acknowledged that big tech is very close with the current administration. Do you think there's more value for them to have one law that they can help potentially influence versus all of these state laws?
Absolutely, it would be beneficial. I think everybody would like to have one law to keep up with instead of 200 plus globally, and even in the United States, the 50, 75, approaching 100 that we tend to see across, because it's not just the states, it's also all the sectors that are different. I think everybody wants it, but there's just at the end of the day, issues around one, and this is tough, is like there's the states' rights issues versus federal, and who should be in control over setting that. And so it's always going to be a battle. But then there are certain issues that are kind of poison pills for each side. The left wants, to have like private right of action and these ways to really be able to have teeth against companies for not following the laws. And then I think that's the opposite's the case on the more business oriented approach. And so I think we may see, I think eventually, I wouldn't be surprised to see this administration try to put something forward, but whether it can truly be comprehensive and kind of push aside all of these different standards, that's just such a tall order, and I think just unlikely for all the people that have wanted it for this long. It's hard for me to see what's different now that's all of a sudden going to make that change this year.
With that, Andy alluded to this a little bit, but there are some other legal issues to keep in mind beyond those effective dates with the new administration, with AI coming into full effect, really, some security and privacy issues. And then, Jonathan, we can talk about employment law. Let's start with AI. Jonathan, I'll pass it to you.
Yeah, with this widespread adoption around AI, there's many more cases that are going to involve the use of AI. And I think many of these cases will go to existing laws because essentially it's just a change in technology. But I do think some of them are unique to how AI operates. So a couple of cases that have been recent are around chatbot interactions with children. There was one case where a chatbot understood that there are times where children have been abused and they've taken the step of actually killing their parents. And the chatbot essentially empathized and recommended that course of action in certain scenarios. And so there's a couple lawsuits relating to that chatbot interaction. Last year, there was a famous case out of Canada where a chatbot gave advice to a customer who was purchasing an airline ticket that the airline ticket was refundable. According to the airline policies, it actually was not. That was the chatbot's mistake. But when they went to court, the court ruled in favor of the customer and essentially said, you need to own what your chatbot is saying. So I think as chatbots become pervasive and every company has a chatbot on their website, it's becoming incumbent on the businesses to make sure that you understand what the chatbot is potentially going to say and to put guardrails in place. I know our team internally has spent a lot of time making sure that the chatbot can only discuss certain subject matters. And they've tried many ways to be able to circumvent that. And they've been successful sometimes. And it can be challenging to try to solve every single way somebody may try to circumvent some of the restrictions you put in place. But as we all start adopting AI in our companies, we are going to be responsible for the output of that AI. Other cases deal with the same types of laws that we've been dealing with just in the AI context. So there have been several enforcement actions around fraud in AI and essentially overselling what your product's capabilities are and tacking on the word AI to make it sound like it's going to be perfect when in fact it's not. And there's been a couple well-noted cases, particularly in the consumer context. There was a case out of Texas, an enforcement action where a product claimed that it could summarize notes, hospital notes. and do that with a very high level of accuracy. It turns out it didn't do that with the level of accuracy that it was claiming, and it was actually creating potential issues for patients. And so there was a settlement there. There's been several other cases around misrepresentation in that consumer context. So I think you are going to see laws that have been on the books for years now applied to the case of artificial intelligence. But I don't think there's really anything novel. It's just a different look at the same problem.
Yeah, I totally agree with that. I think what comes to mind when you talk about all these different use cases is one thing we talk to a lot of our customers about is you've been preparing for inevitable privacy incidents and cybersecurity incidents that your company will face, but you can, as Jonathan laid out, you can spend all the time in the world trying to ensure that your chatbot doesn't perform in a way you don't want it to, but there's always going to be some edge cases where who knows how something happens. I'd say just more broadly, you think about all the ways that a company might be adopting AI and products you offer, your commercial interactions on the website, ways that people are using it to be more efficient within the enterprise. There's the reality that there's tons of value that's you're getting, and it's worth the risk, I think, for a lot of businesses to do that. But it's also worth spending some time thinking about what are you going to do when these inevitable situations happen. And I know a lot of customers look at it in some of the parallels we do in the privacy space, where we do these privacy impact assessments of doing whatever kind of data processing or other ways you want to use certain customer information. You can think about AI in a similar way of assessing is like not only just documenting what you plan to do with this, but just having some sense of what are the ways this could go afoul, and what do we want, what kind of process do we want to have in place to deal with that type of situation, so that you're not kind of left scrambling when that thing happens to say, okay, well, we've got no plan in place. Let's just seat of our pants, figure out what we're going to do. It's worth, even if it starts as a kind of a high level frameworks that you want to have for, okay, here's our general process. Here are the people that are going to be involved. Same way you have a incident response team on the cybersecurity side, you probably want an AI incident team that is going to involve a lot of the same players. It's going to have legal team. It's going to have comms, probably some executive leadership. And it's really worth thinking about that, because I think we're going to see, we had all this adoption last year. Here come some of the crazy use cases that we've already heard, some of the ones that Jonathan talked about a moment ago. And I think it's critical for your business to be prepared for that.
That's such a good point. And I think the legal team, it's incumbent on us, for those who are in-house lawyers, to really lead the charge there. You don't want an error occurring and 3 weeks later the legal team's notified of it. You want to treat that like an incident, like you would a cybersecurity breach or many of the other incidents that Andy was talking about.
Should we move into the new administration and what that means for a few different factors here?
Yeah, sounds good. Yeah, obviously we're fresh off the change, and we've already seen a lot of activity. We were discussing earlier, John, the executive orders that were signed on day one. So there's a lot of activity, a lot of desire to change the way things have been done. I think the ones that are making the biggest headlines are the ones we've laid out here: immigration, crypto, and tariffs. I think that it's going to be interesting to see how that plays out in court, because I think there's a lot of stuff that will be challenged immediately, or has already been a challenge, I think. But these are a few of the areas that we're already seeing making headlines on day one.
Yeah, and just to put one quick clarification, not all of these are executive orders yet, but these are areas where we expect for the administration to take action.
Yeah, totally.
Yeah, and I would just note crypto is an area where I'm following closely, because I think there's going to be greater adoption with the new administration. There's some accounting and other regulatory issues, that particularly with the SEC, that have potentially slowed adoption of crypto. I think the change in administration will lead to some changes that accelerates it. Doing some initial research on this, there looks to be about 90 to 100 public companies that are currently using crypto or have crypto holdings. MicroStrategies has disclosed that they have billions of dollars of crypto that only increased over the last few months. So I do think this is an area where, as legal counsel for a company, out of nowhere, someone may ask you for your advice on some crypto holdings that the company wants to buy. And it's an area that I think we're all going to have to get up to speed on.
Yeah, and it's clear that was one of the, there's some policies that it's not clear exactly which direction the new administration is going to go on. I think crypto is one that was pretty loud and clear going into the election, that this was an area where they planned to back off a lot of this SEC enforcement that it has slowed everything down.
Jonathan, should we move into employment law?
Yeah, I think a couple areas to highlight in the employment law space right now. One, I would say, is there's new pay transparency acts that are being enforced starting in 2025. There were several acts that had already come into effect last year. And this year, there's at least 5 new states, including Illinois, Massachusetts, Minnesota, New Jersey, and Vermont, that are set to have their laws become effective this year. The key takeaways to know about pay transparency laws are that when you post a job, you have to have a band in most of these laws of what the wage is going to potentially be, and it actually has to be realistic. There's other key items that are probably going to be more specific to each law around what else needs to be posted. So something to keep an eye on as these laws become more prevalent. One law out of Illinois that I could see starting to become adopted by other states is a new law around discrimination for family responsibilities. Essentially, it prohibits employers from discriminating where an employee has family responsibilities. So take the case where somebody has to go take care of an aging parent and they have to leave the office or their remote work situation just a little bit early to go take care of those responsibilities. This will now prohibit an employer for essentially dinging them for taking that time off to go take care of those responsibilities. I think this is just part of a general cultural shift in society post remote work that does allow employees to have a little bit more flexibility in their life to take care of important things. In addition to that, just as of yesterday, the EEO 11246 was repealed, and that was the executive order that dealt with affirmative action and non-discrimination for companies that are contracting with the government or subcontracting with the government. I would still note that Title VII is still in effect that does prohibit discrimination, and there are a number of state laws that do prohibit discrimination, but some of the affirmative action pieces of the executive order are probably not anywhere else. So that will be an interesting change, as that executive order has been on the book for years. Lastly, it'll be interesting to see how the new administration handles non-competes. The FTC had created a rule prohibiting non-competes. It's being held up in the courts right now. It'll be interesting to see whether or not the administration repeals that ban or whether they let the courts handle it.
A lot to keep track of there, Jonathan. Andy, do you want to close us out on these key legal issues on security and privacy?
Yeah. So I think one of the trends that we see in the security and privacy space is when you have major breaches or incidents that impact broad parts of the economy, then we often see some kind of legislation created afterwards to try to say, okay, let's put some kind of guardrail in place or something that they want to affect from a policy perspective to say, hey, we're trying to do our best to make sure this doesn't happen again. In the security space, a lot of that comes down to speed to report things and number of people that need to report things. So I think one of the ones we're calling out here is the supply chain issues. So the CrowdStrike incident, it was not a breach, but that day that everybody at the airport got delayed, had blue screens all over the place, really raised this specter to folks that like, hey, there's a lot of technologies that become ubiquitously relied upon by lots of different companies. And then when something goes down like that, to really knock those people out of running their businesses, just has a tremendous impact on everybody's life. And so I think what we'll see is some more regulation in that direction. So a lot of reporting around security incidents. And I should also say this is about availability too. So like we've always talked about, okay, what about when you get attacked or there's an improper disclosure of data? But now we really talk about it. And it's actually always been part of what they call the CIA triad in security. Is one of those pieces is availability. That's what the A is for. And so I think we'll see more on desire to make that more of a reportable issue, and really not just the company that is the root of it that say, okay, like, when we think about the breach context, the company that got breached, but it can also be all the other companies involved. And so you can potentially have multiple parties needing to report on availability issues because of one particular vendor's problem. And so I think we will see that. I think similarly, we saw a little bit of wave of this last year, and I think it'll come into this year too, as we've had so much on the healthcare space with the Change Healthcare breach that impacted so many. I think we'll see more of that come into effect. And I should also say that there's also this kind of push-pull between federal laws and state laws. And if it is a case that this administration is doing less regulating on the federal front in this domain, we see a lot of state laws kind of step up and do more. And you've already seen some attorney generals saying as such. And so I think you could see more on the state front from some of the states that are more aggressive in these spaces.
Jonathan, anything to add before we move on?
No, it's a lot coming at everyone all at once.
Definitely. And that's kind of my next question. What are you guys doing to keep everything in check? There's obviously a lot going on. What tools or tips or tricks do you have for everyone on the call to keep their ducks in a row? And like, what are the things that people can be doing to keep all of this in mind? Jonathan, I'll start with you.
Yeah, I think staying organized both personally and in a team context has been really important. There's a lot of questions that will come up. And I think one of the biggest time wasters is when folks in your organization come to different people, they do discrete work and nobody ever talks and shares and there's no records. So I think having more tooling that allows your team, particularly if you're in a team dynamic or even your own self, having your own work organized to where you're able to provide consistency to advice as in-house lawyers to your team. So if you get the same question comes to two different people, immediately to go to one place. If the question gets asked 6 months after it was originally asked and answered, that you have the record of what was said back then. I think all of that will become really important as all of these laws change and folks start looking to the legal team to dispense advice.
Such great advice. Consistency. I think that is one of the themes there, that especially if you look at actions against the company, whether it's a lawsuit or a regulatory investigation, seeing that you responded to things the same way each time, whether it's on the cybersecurity front or another legal matter, is super, super important, because those differences, when you don't do it that way, those are, what really comes out in discovery and becomes a problem. And I'd say some of the efficiency tips from my perspective, I think, actually adding on to what Jonathan was saying about being very organized in how you're record keeping and of all the work that your team's doing, and really having clear responsibilities, who owns what and maintains that information in those different subject areas, is really important. And then there are a lot of ways that, as much as the legal team needs to be aware of all the business uses of AI, that the legal team can apply AI to the unique data sets that you have. And I'll just give an example for us at PreachRx. One of the products we created it's called Cyber Reg Scout, where we've taken all of those 200 plus global laws and made it a very easy place to search and sort through. We've added an AI chatbot to it, so it's a way for you to interact with the research. There's more and more accessible ways to apply these AI tools to your unique data set and not have it be shared or trained on other models, but just really a way to efficiently find answers with work you've already done, draw conclusions. Obviously, you need to always check things to make sure that they're correct, but just getting that initial starting point, like whether it's email drafting that's mentioned here, or just an initial getting the bare bones of outline going on something, that's, in my mind, such a huge piece of efficiency, because that always seems to take the biggest energetic lift is this like the quick the first draft. And if you can be editing something or adjusting something and just verifying, that is a lower energy lift and I think drives more efficiency. And it's a way that everybody in your org will appreciate legal team moving faster and getting things done. And so I think being able to leverage these tools is super important for that.
Yeah, and I have to say, with the legal research piece of it, AI is incredible. But the more and more bespoke tools that you can use that really focus on making sure the prompts are focused for a legal audience do tend to have less errors. Like you said, you always have to double check. I think it's so convincing when you get a response. It's just so easy to skip rule number one, which is always fact check. But I have found that the quality of results can truly differ between products.
Really.
Fantastic. Thank you both. We're nearing time, so I just want to quickly go through a couple of next steps that everyone can think about as we're heading into the rest of the year. Jonathan said earlier, try to stay on top of new laws and trends. Just do your best to stay on top of everything. Everything's moving very rapidly, so that's something to keep in mind. Review those new executive orders that Jonathan and Andy both mentioned. First, define and refine your processes, build out your teams, who's responsible for what, as we just were talking about. And then we're also planning on doing a follow-up webinar on a lot of these things. A lot has changed in 3 weeks. A lot has changed in 3 days as this landscape is evolving and changing. Just like really staying on top of everything is key here. And we'll send out some additional resources for all of you, the 2025 forecast that I was mentioning before. And then we also have a list of all the laws mentioned throughout the webinar with their summary. So we'll also get that out. But thank you everyone so much for joining. We love doing these and keeping everyone aware of all the changes. And thank you, Jonathan, Andy, as always, for your wealth of knowledge.
Thanks. Great seeing everybody.
Thank you. Bye.